Okay, let's unpack this. We've got a truly significant deep dive today, straight from a U.S. courtroom. We're talking about a brand new ruling, hot off the presses, really, that directly challenges the president's power to impose major tariffs.
Yeah, this is big.
And this isn't academic. It's a real-world decision that has just struck down substantial tariffs, finding them unlawful, and, well, setting them aside. The implications here are huge, affecting everything from supply chains and consumer costs to, the fundamental balance of power between the White House and Congress.
That's exactly where we're heading. Our focus is the source material, a 39-page opinion released just on May 28, 2025, by the United States Court of International Trade.
CIT, right.
Exactly. This opinion covers two consolidated cases, VOS Selections, Inc., et al. Versus the United States, et al., and the state of Oregon, et al. Versus the United States Department of Homeland Security, et al. The court's job, basically, was to untangle some really knotty questions about presidential authority, specifically under a law called the International Emergency Economic Powers Act, or IEEPA.
IEEPA. Okay. So the court looked at whether this law passed back in, 1977.
77, yeah.
Whether it actually gives the president the power to do what he did here. And the core question, as the court states it pretty clearly in their opinion, is whether IEPA delegates Congress's constitutional powers. Those powers to tax, imports, and regulate foreign commerce found right there in Article 1, Section 8 of the Constitution.
Yeah.
Whether IEPA gives these powers to the president in a way that lets him slap basically unlimited tariffs on goods from almost every country in the world. That's a big question.
It is a massive question, yeah. I mean, it goes right to the heart of who controls trade policy in the United States. And the court's answer, after digging through the law, the history, the facts of these particular tariffs, well, it's a definitive no.
A clear no.
A very clear no. They granted summary judgment for the plaintiffs, that's the coalition of businesses in a dozen states, and denied the government's defense entirely. The practical effect, the challenged tariffs are vacated, set aside, and permanently blocked. Gone.
Permanently blocked. Wow.
Yeah. The court essentially found the president acted outside the authority granted by Congress in these specific instances.
So our mission in this deep dive is to kind of pull back the curtain on this decision. How did the court get there? We'll walk through the legal landscape the court navigated, the specific tariffs that were challenged, and the step-by-step reasoning the court used to, well, dismantle the government's arguments.
Yeah, think of it like getting a guided tour through a pretty complex legal puzzle.
Right. Understanding the pieces, the rules, and how the court put them together to reach this outcome. We'll look at the historical context, the statutory language, the key legal precedents, all the stuff that shaped this ruling.
And as the court does, we kind of have to start with the basics of U.S. law regarding trade and tariffs. The foundation really is the Constitution, Article 1, Section 8. This vests the power to lay and collect taxes, duties, imposts, and excises, and to regulate commerce with foreign nations, squarely with Congress.
With Congress, not the president.
Not the president. This isn't just some procedural point. It's a core principle of the separation of powers. Tariffs are a form of taxation. They're a tool for regulating commerce. And constitutionally, that's Congress's job.
Congress's job, but we know Congress can't micromanage everything, right? Especially in a complex global economy. So they do delegate some authority to the executive branch, don't they? The court acknowledges this.
Oh, absolutely. The court definitely acknowledges that Congress can delegate some of this authority. They even cite the Supreme Court, noting that Congress can't foresee every single situation, citing a case called American Power and Light Co. from way back in 1946. If they had to write specific legislation for every tiny potential issue, well, the legislative process would just grind to a halt. So delegation is necessary. It's practical.
But there are limits to that delegation. Congress can't just, give away its power entirely. This brings us to the non-delegation doctrine, which the court talks about quite a bit.
Yeah, it does. The non-delegation doctrine is basically the principle that Congress has to provide an intelligible principle, essentially a clear standard or guideline to direct the executive's use of that delegated power.
An intelligible principle.
Okay, it comes from cases like J.W. Hampton in 1928 and Mistretta in 1989. Congress can't simply give the president a blank check. There has to be some kind of framework, limits, direction for how that power is supposed to be used. The court really emphasizes that this intelligible principle needs to meaningfully constrain what the executive can do.
Okay, so delegation is allowed, but it needs guardrails. Got it. And the court brings in another doctrine, which seems particularly important for really big issues, the major questions doctrine. This feels pretty key to their analysis here.
It is. It's very relevant. The court cites recent Supreme Court cases like West Virginia v. EPA and Biden v. Nebraska. The major questions doctrine basically suggests that for issues of vast economic and political significance, and let's face it, imposing tariffs on goods from pretty much the entire world definitely qualifies.
Yeah, I'd say so.
Courts should be very hesitant to find that Congress delegated such sweeping authority unless Congress has, quote, spoken clearly about its intent to do so.
So if the executive branch claims some huge power based on kind of vague language in an old statute, courts are going to look really closely and say, show us where Congress clearly said you could do that.
Precisely. It's an interpretive tool the courts use to protect that separation of powers. It signals that if Congress wants the president to have power over something as massive as, say, global tariff policy, it needs to say so explicitly, not just bury it in general language somewhere.
Okay, this context is super important. Now, the court also looked at the history of tariffs and how presidential authority in this area has, well, evolved. Tariffs weren't always used the way they were in these challenged orders.
Well, not at all. Historically, especially early on, tariffs were primarily about revenue. That was the main way the federal government actually made money. The court references some historical work on this.
Before income tax, basically.
Exactly.
Yeah.
The 16th Amendment, allowing for income tax in 1913, changed that picture significantly. Tariffs then kind of morphed into tools for restricting imports, protecting specific industries, or maybe gaining leverage in trade negotiations. Different purposes over time.
And as trade got more complex, Congress started setting up specialized structures and delegating specific trade authorities. But you mentioned with limitations, the court highlights examples where Congress was pretty precise about this.
They do. They point out that Congress created the U.S. Tariff Commission, which is now the International Trade Commission, or ITC,
Right.
a body with expertise to investigate trade matters. And they emphasize that the harmonized tariff schedule of the United States, the HTS-US, the big list of all the tariffs, that itself is a statute. It's a law passed by Congress.
Okay.
And when Congress has delegated tariff authority, it's often been quite constrained. For instance, Section 232B of the Trade Expansion Act of 1962 lets the president adjust imports for national security reasons.
We hear about 232 a lot.
Yeah, but only after the Commerce Secretary does an investigation and makes specific findings. It's a defined process with a specific trigger, not just, I think there's a problem.
Okay, so a specific condition and a specific process. What about Section 301 of the Trade Act of 1974? That's another one often used for unfair trade practices.
That's another example the court uses to make its point. Section 301 lets the U.S. Trade Representative, the USTR, respond to unfair trade practices with actions like tariffs. But again, it requires extensive procedural steps: an investigation, a formal finding of unfairness, public notice, comment periods. These are all designed to limit discretion and ensure some transparency.
So Congress has shown it knows how to delegate tariff authority with specific conditions and procedures attached when it wants to.
Exactly. They know how to put limits on it.
This history of careful delegation makes the next part, the evolution of emergency powers, even more interesting. The court digs into the Trading with the Enemy Act of 1917, TWEA.
Right. TWEA is kind of the granddaddy law here, the predecessor to IEEPA. Passed during World War I, it gave the president really broad powers to regulate transactions and trade with enemies. But its authority was later expanded during the Great Depression to cover peacetime emergencies too, using similar broad language about, quote, regulating importation.
And that broad language led to these critical Yoshida cases in the 1970s that this court relies on heavily, right?
Absolutely pivotal cases.
Yeah.
In 1971, President Nixon used TWEA, that older, broader law, to impose a 10% supplemental duty on all dutiable imports, citing a balance of payments emergency. This got challenged.
Okay.
In Yoshida I, the lower court actually said, nope, TWEA doesn't allow this, and finding that kind of power would violate Congress's control over tariffs. But then, in Yoshida II, the appeals court reversed. They did uphold Nixon's tariffs under TWEA. They said the power to regulate importation could include tariffs, but, and this is the crucial part, it had to be appropriately and reasonably related to the particular nature of the emergency declared.
So Yoshida II said, TWEA allowed tariffs, but with a condition, a reasonable relation to the specific emergency, and that court also issued a warning, didn't it?
A very important warning, yes. The Yoshida II court upheld Nixon's tariffs specifically because They were limited, they were capped by the existing tariff rates in the HTS-US, and they were temporary, directly tied to that balance of payments crisis. They explicitly warned against interpreting TWEEDBEA as granting an unlimited power to impose any tariff the president felt like imposing.
Okay.
They said upholding Nixon's specific limited surcharge was, quote, quite different from allowing the president to essentially rewrite the tariff schedules. And they warned that finding unlimited power would be a, quote, blow to our Constitution.
That warning seems incredibly relevant to the tariffs being challenged today, and it sounds like Congress maybe heard that warning after Yoshida II, which led to the reforms in 1977 that created IEEPA.
Yes, exactly. That seems to be the case. Congress reviewed those broad emergency powers under TWEEA and decided they need to be reined in, particularly for peacetime. So TWEEA was restricted mostly to wartime situations, and they passed IEP specifically for peacetime national emergencies.
Okay.
The court quotes the legislative history, which states clearly that IEP was intended to provide a new set of authorities, both more limited in scope than those of TWEEA and subject to more procedural limitations, including those of the National Emergencies Act. Congress's explicit goal was to reduce the scope of peacetime emergency power compared to what TWEEA offered.
Wow. So IEP was deliberately designed to be less powerful than the TWEEA authority that Yoshida II had just interpreted, which itself was seen as potentially problematic if unlimited.
Precisely. That's the context. And alongside IEP, they passed the National Emergencies Act, or NEA, to provide a framework for declaring and overseeing emergencies. This included requirements for notifying Congress and periodic reviews. Originally, Congress could terminate an emergency relatively easily with something called a concurrent resolution.
But that changed, right? Because of the Supreme Court's Chadha decision, the legislative veto case.
Right. Chadha in '83 basically found legislative vetoes unconstitutional because they bypassed the president's role in lawmaking, the whole presentment clause thing.
Okay.
So following Chadha, Congress amended the NEA. Now, terminating an emergency requires a joint resolution. And critically, a joint resolution can be vetoed by the president.
So it has to go through the whole legislative process, including potentially overcoming a veto.
Exactly. As the court in this case points out, this makes congressional review under the NEA effectively no more than the ordinary power to legislate. It's much harder for Congress to unilaterally end an emergency declaration if the president doesn't want it to end. So that check got significantly weaker.
So Congress tried to rein in emergency powers with IEEPA and the NEA, but the effect of Chadha inadvertently made one of those key checks much less effective.
That's interesting. And the court notes that the plaintiffs here aren't challenging the declaration of emergency itself under the NEA, but the action taken the tariffs under IEEPA. Correct. That's a key distinction. The question isn't whether there was an emergency, legally speaking. The question is whether the president's response to that declared emergency falls within the boundaries Congress set in the IEEPA statute itself.
Got it. So what are the key IEEPA provisions here?
Well, Section 1702A1 is the broad authority the government relied on. It allows the president to regulate importation of any property in which any foreign country or a national thereof has any interest. That's a language that sounds kind of similar to TWEA.
Right, the language Yoshida II looked at.
Yes. But crucially, the court highlights Section 1701B as a significant constraint, maybe the significant constraint here. It says IEPA authorities may only be exercised to deal with an unusual and extraordinary threat and may not be exercised for any other purpose.
Okay, only to deal with the threat.
Right. The court breaks this down. The action must be taken because of a declared emergency threat. The threat has to be sourced outside the U.S., and critically, the action taken must actually deal with that specific threat. It's not enough to just declare an emergency. The action has to be directly aimed at addressing that particular threat.
Okay, so the action has to be linked to actually solving the declared problem. Before we dive into how the court applied that to these specific tariffs, let's quickly clarify jurisdiction and standing. Why is this court, the Court of International Trade, hearing this case? And how did the businesses and states prove they actually had the right to sue in the first place?
Good question. The Court of International Trade, the CIT, confirms it has exclusive jurisdiction under a federal law, 28 U.S.C. Section 1581. This law basically gives the CIT jurisdiction over challenges to the enforcement or administration of laws providing for revenue from imports or import restrictions.
And these tariffs definitely qualify.
Oh, yeah. Since these executive orders imposing tariffs under IEEPA are clearly actions arising from laws about import restrictions, and they directly amend the HTS-US, that statutory tariff schedule, the challenge belongs squarely in the CIT. The court does note, interestingly, that while you can't technically sue the president directly under this statute, you can challenge the legality of his actions by suing the government officials who are tasked with implementing them, like Customs or Treasury, which is what happened here.
Got it. Makes sense. And standing. Did the plaintiffs show they were actually harmed enough to bring the suit? The government usually fights hard on standing.
They do, but the court found standing here for both the business plaintiffs, like VOS selections, and the state plaintiffs. Under Article 3 of the Constitution, you need to show a concrete, imminent injury that's traceable to the challenged action and that the court can actually fix. For the businesses, they provided declarations, basically sworn statements detailing specific economic harms, troubles sourcing goods, increased material costs making their products way too expensive, major strain on cash flow, delayed shipments, some even saying they were at risk of going out of business, and of course, direct payment of substantial tariffs.
Real money, real impact.
Exactly. And the court cited cases showing you don't necessarily have to be the one who physically pays the duty at the border to have standing. Showing a likely economic injury caused by the tariff is often enough.
And what about the states? How did they show harm?
For the states, the court found standing maybe even more straightforward. The states argued direct financial harm from the increased cost of importing goods they need for public services, things for schools, infrastructure projects, etc. This impacts their budgets and procurement processes. Some states were also direct importers themselves who had paid tariffs, which is sort of a slam dunk for standing. And since the relief they all wanted, getting rid of the tariffs, would benefit all the plaintiffs, the court said it didn't even need to analyze the standing of every single state individually. If one has standing, that's often enough. So, yes, the court had the power to hear the case, and the plaintiffs had the right to bring it.
All right, the stage is set. We understand the constitutional powers, the limits on delegation, the history leading to IEPA, the court's role. Now let's get to the tariffs themselves. There were two distinct sets challenged in this case, right? Let's start with the worldwide and retaliatory tariffs.
All right. The worldwide and retaliatory tariffs were imposed a bit later on April 2, 2025, via Executive Order 14257. In that one, the president declared a national emergency citing sort of underlying conditions, things like lack of trade reciprocity, different tariff rates between countries, non-tariff barriers, foreign policies suppressing wages, a whole laundry list.
Kind of broad reasons.
Very broad. And he stated these conditions were evidenced by large and persistent annual U.S. goods trade deficits, and that these deficits posed an unusual and extraordinary threat to national security and the economy.
So the stated reason was basically trade imbalances and deficits. Got it. What were the tariffs themselves? What did the order actually do?
Initially, it was incredibly sweeping. A 10% ad valorem duty, that's a percentage of the value on all imports from all trading partners, globally.
Wow. Okay. 10% on everything.
Pretty much. And on top of that, there were higher rates ranging from 11% up to 50%, except for a specific list of 57 countries. Now, the court notes there were a lot of modifications later. The higher country-specific rates got paused for most countries except China for a while. And there were specific retaliatory increases just targeting China under this order, which saw its rate jump dramatically at one point.
Retaliation for their retaliation, basically.
Kind of a tit for tat, yeah. Before it was eventually lowered back to the 10% worldwide rate under this particular order, though importantly, China was still subject to the separate trafficking tariffs we'll get to. So, as of the court's opinion, you basically had that 10% global rate in effect, with those higher rates still potentially looming for specific countries down the road, except for China, which was at the 10% rate under this order, but facing a combined rate because of the other tariffs.
Okay, so very broad tariffs applied globally, explicitly linked by the president to trade deficits. How did the court analyze these tariffs under IEPA?
Okay, so this is where the court applies that legal framework we talked about, non-delegation. Major questions, IEPA's limits. The plaintiffs argued, essentially, that IEPA's regulate importation language just doesn't authorize tariffs this broad and unlimited. They said finding such authority would violate those non-delegation and major questions doctrines. The government, on the other hand, argued that phrase means the same thing it did in 2DEA, and Yoshida II said 2DEA included tariff power.
Kind of a battle over the meaning of regulate importation. And the court sided with the plaintiffs on this set.
They did, yes. The court ruled that while IEPA might, theoretically, grant some very limited tariff authority, maybe like what Yoshida II found for 2EA in that specific limited context, it certainly does not authorize tariffs as unbounded in rate and duration as these worldwide and retaliatory tariffs were.
Unbounded being the key word there.
Absolutely. And the court explicitly uses the non-delegation doctrine, the major questions doctrine, and the general separation of powers principles as tools to interpret IEPA. They basically read the statute narrowly to avoid the serious constitutional doubts that finding an unlimited delegation of tariff power would inevitably raise.
So they're interpreting the statute in a way that keeps it constitutional. How did they contrast this situation with the tariffs that were upheld back in Yoshida II? That comparison seems critical.
It was crucial, yeah. The court hammered this point home. They highlighted that the tariffs in Yoshida II were upheld precisely because they were limited, remember, capped by existing HTSUS rates and temporary, tied directly to that specific balance of payments emergency. The worldwide and retaliatory tariffs here, the court found, had no such limit on their rate or duration. They could be anything, last forever, essentially.
Right.
This, the court said, is the exact kind of unbounded power the Yoshida courts specifically warned against granting. And the court also pointed out, remember how we discussed the weakening of congressional review under the NEA after Chadha?
Yeah, the veto power making it harder for Congress to stop it.
Right. The court said that makes the risk of this kind of unbounded presidential action even more concerning today than it was back in the 70s. The check isn't as strong.
So the court is basically saying IEPA wasn't meant to be as broad as TUIE's prior interpretation, especially given its legislative history, that goal of limiting power and the context of other specific trade laws Congress passed.
Exactly. The court keeps coming back to that legislative intent. Congress meant for IEPA to be more limited than TUIE. They cited the legislative history again, showing Congress wanted routine, non-emergency regulation handled by other legislation. And this becomes the absolute core of their finding for these specific tariffs, that other legislation actually exists for this exact problem.
Ah, okay. Is this where the Trade Act of 1974, specifically Section 122, comes into play?
Yes, bingo.
Yeah.
This is the linchpin for the worldwide tariffs. The court points directly to Section 122 of the Trade Act of 1974. Its title, Balance of Payments Authority.
Pretty specific.
Very specific. The court notes that this statute was created for the explicit purpose of dealing with international payments problems, including, quoting the statute, large and serious balance of payments deficits.
Yeah.
That's the very problem the president cited as the reason for the worldwide tariffs, right?
Yeah.
Because trade deficits are a type of balance of payments deficit.
Okay, so Congress already made a law for this exact situation.
Exactly. And critically, Section 122 contains specific, narrow limits on what the president can do in this area. There's a 15% tariff cap and a 150-day duration limit for any temporary surcharges, specific guardrails.
So Congress created a specific limited tool, Section 122, for dealing with trade deficits and balance of payments issues.
Precisely. And the court's decisive finding here is that when Congress provides a specific, limited statutory authority to deal with a particular problem like trade deficits via Section 122, the president must use that specific authority and adhere to its limits. He can't just bypass the limitations Congress put in that specific statute by instead invoking broader, more general emergency powers under IEPA Section 1702 to address the exact same problem.
Wow.
The court essentially says Section 122 carves out these balance of payments issues from IEPA's broader, more general scope.
So the court is saying Congress gave you a specific tool, like a scalpel, Section 122, with its limits for the specific surgical issue trade deficits. You can't ignore the scalpel and decide to use a chainsaw, i.e. EPA, just because it's a bigger tool, especially when that chainsaw wasn't designed for this specific cut. And crucially, IEPA itself was meant to be more limited than its predecessor anyway.
That's a fantastic analogy. That's exactly the logic. The existence of the specific limited authority in Section 122 for balance of payments issues means that IEPA, by its design as a more limited statute and its general purpose nature, does not authorize unbounded tariffs for that specific purpose.
Okay.
So since the worldwide and retaliatory tariffs were explicitly imposed to address trade deficits, a balance of payments problem, and they clearly did not comply with Section 122's limits, they were unbounded in duration, potentially exceeded the 15% cap. The court found they exceeded any tariff authority delegated under IEPA in this context. They were ultra-vires, meaning beyond legal authority and therefore invalid. That's the first major pillar of the ruling.
Okay, that makes a lot of sense. It's about using the right tool Congress provided for the job and respecting the limits Congress put on that specific tool. Now let's turn to the second set of tariffs the court looked at, the trafficking tariffs. What was the story behind those ones?
Right, the trafficking tariffs. These were actually some of the first actions taken, starting literally the day of the president's inauguration, January 20, 2025, with Executive Order 14157. The declared emergency there related to international cartels, border security threats, criminals, terrorists, human traffickers, drugs, fentanyl precursors, that kind of thing.
A very different kind of threat than trade deficits.
Very different. And specifically, the EOs cited the failure of Canada and China to do more to intercept these threats within their own jurisdictions. Later orders expanded this to Mexico, too.
So the threat was defined as these other governments not doing enough to stop bad actors and illicit goods on their own turf. And the U.S. response was tariffs.
Yes. Tariffs on lawful goods. Initial tariffs were 25% on products from Canada and Mexico, 10% on products from China, plus an additional 10% on Canadian energy resources. The executive orders explicitly linked these tariffs to the alleged failure of Canada, China, and Mexico to arrest, seize, detain, or otherwise intercept traffickers in drugs.
Okay.
Now, like the others, there were modifications and pauses. Later, the Canada-Mexico rates got paused for a bit, citing cooperative actions. The China rate got raised to 20%. Some specific product rates like potash were adjusted, but the core action remained. Imposing tariffs on a broad range of ordinary lawful imports from those countries tied to their government's alleged failure to act against trafficking and related threats within their own borders.
And the court found a different, separate reason for invalidating these tariffs compared to the worldwide ones. They didn't rely on Section 122 here.
Exactly. No Section 122 issue here. Instead, the court found the trafficking tariffs violated that other key condition in IEEPA we discussed, Section 1701B. Specifically, the requirement that the authority may only be exercised to deal with the declared threat and may not be exercised for any other purpose. This was the second distinct legal problem the court identified.
Okay, the deal with requirement. Did the government argue the court couldn't even look at this? Did they raise that political question doctrine argument again, saying it's up to the president to decide if his actions deal with the threat?
Yes, they absolutely did. They argued that judging whether an action deals with a national security threat is a political question, something only the executive branch can decide, and that there aren't any, quote, judicially manageable standards for a court to apply.
And the court's response to that?
A pretty strong rejection, actually. The court firmly stated that interpreting statutory text, including phrases like deal with, is precisely the judiciary's core function. That's what courts do. They cited cases like Japan Whaling Association and Zivotofsky, emphasizing that courts routinely interpret statutes to determine the limits of executive authority. This isn't about second-guessing the president's policy wisdom. It's about figuring out if the action fits within the boundaries Congress actually set in the law.
Right.
They compared it to reviewing agency findings under other laws, like anti-dumping laws. Courts do that all the time by applying the statutory standards Congress wrote. It's about ensuring the president acts within the legal framework, which, they noted, Justice Jackson's famous concurrence in the Youngstown steel seizure case highlighted as a crucial judicial duty, determining which zone of power the president is operating in.
So the court is saying its job is to make sure the president's action fits the requirements Congress wrote into the law, not to decide if it's a good policy or a smart strategy.
Precisely. That's the line they draw. And the court stressed that Section 1701B, that deal with language, is a substantive requirement. It's a meaningful constraint, not just some box the president has to check by mentioning the threat in his order. The language may only be exercised to deal with. Means the action taken must have a genuine, direct connection to addressing the declared threat. It can't just be a pretext for doing something else. Congress added this specific language for a reason, the court said, and courts have to assume it has real and substantial effect.
Okay, so the court can review this deal with requirement. Why did they find the trafficking tariffs failed that test? What was the disconnect?
The court found there was no evident direct link between the action taken imposing tariffs on vast categories of lawful imports from Canada, Mexico, and China, and the declared threat, which was those foreign governments' alleged failure to arrest, seize, detain, or otherwise intercept traffickers in drugs within their own borders. The court's understanding of deal with requires some kind of direct causal connection. They use simple examples. A tax deals with a deficit because it raises revenue. A jam deals with flooding because it holds back water. There's a direct mechanism.
So taxing Canadian furniture or Mexican avocados doesn't directly stop a cartel member operating inside Mexico or prevent precursor chemicals from being shipped within China.
That's exactly the court's point. There's no immediate logical connection showing how taxing unrelated lawful goods directly impacts the internal law enforcement failures of those other countries, which was the stated emergency. Now, the government did suggest, sort of, that maybe these tariffs deter smuggling within lawful trade shipments, but the court found the executive orders themselves didn't really support this theory. The EOs were squarely focused on the foreign government's failure to act internally, not on smuggling methods.
And what about the government's main justification? It seemed to be that these tariffs created pressure or leverage on the foreign governments to get them to change their ways.
Yes, this was the absolute key point the court took apart. The government basically conceded that the purpose of the tariffs was to exert pressure, to create leverage, to compel the foreign governments to change their behavior regarding trafficking and border security.
It sounds like diplomacy, maybe? Or coercion?
Well, the court characterized it as a diplomatic strategy to gain leverage, and they found that using tariffs as leverage for unrelated concessions is not what the statute means by dealing with the threat under Section 1701B.
Okay, why is that distinction between using tariffs as leverage versus using them to deal with the threat so critical legally here?
Because in the court's view, if deal with simply means create pressure or gain leverage, then Section 1701B's limitation becomes essentially meaningless. It loses all its teeth.
Yeah.
Well, think about it. Any action that imposes some kind of burden or cost on a foreign country could theoretically be justified by claiming it's creating leverage to get them to change some unrelated behavior regarding any declared threat. The court stated this interpretation would mean everything is permitted, which directly contradicts IEEPA, saying the power may not be exercised for any other purpose than to actually deal with the specific threat.
Right, it would gut the limitation.
It would render it superfluous. The court concluded that Congress didn't intend for IEEPA's emergency powers to be a tool for general diplomatic leverage on unrelated issues. It was meant for actions that have a direct connection to addressing the specific emergency threat itself.
That's a really powerful argument against using IEEPA for broad diplomatic pressure campaigns via tariffs on unrelated goods.
It is. And the court actually went back to that reasonable relation test from Yoshida II, stating that using tariffs on essentially all products as generic leverage to compel unrelated concessions like getting a foreign government to improve its internal law enforcement just doesn't meet that test. The means aren't reasonably related to the ends in the way the statute requires.
Okay.
And again, the court was careful to stress they weren't judging the policy wisdom of using tariffs for leverage. Maybe it works, maybe it doesn't, but it's legality under the specific words Congress chose to put in Section 1701B. Since the trafficking tariffs were based on what the court called a clear misconstruction of that crucial deal with condition, the court found them to be actions outside delegated authority, invalid.
They even cited Justice Story from a really early case, 1815, the Orono, basically reinforcing the judiciary's long-standing role in interpreting laws and determining if the executive has stepped outside the power granted by those laws.
Absolutely.
Yeah.
It underscores that this isn't some new idea. It's fundamental to the judicial role in our system of checks and balances. The courts are the final arbiters of what the law means and whether executive actions comply with it.
So bringing it all together then, the court's findings basically boiled down to two main distinct reasons for invalidating these two sets of tariffs.
Correct. Two separate pillars. Reason one, for the worldwide and retaliatory tariffs. Those were imposed to deal with trade deficits, but Congress had already provided a specific limited tool for that exact problem, Section 122 of the Trade Act. The president couldn't bypass those specific limits by using IEEPA's broader, more general emergency powers, especially since IEEPA itself was meant to be more limited than its predecessor, 2WEA. Using IEEPA for that purpose was ultra-vires.
Okay, that's pillar one.
Pillar two, for the trafficking tariffs. Those were invalid because the action taken imposing tariffs on broad categories of lawful imports did not deal with the declared threat, which was foreign governments failing to intercept traffickers and drugs within their own borders. That link wasn't direct enough. Instead, the tariffs functioned as unauthorized diplomatic leverage, which isn't permitted under the specific constraints of IEEPA Section 1701B.
And the practical result of these two findings?
The court granted summary judgment for the plaintiffs, the businesses, and the states. They won their case, basically. The court vacated and permanently enjoined both sets of challenge tariff orders. That means those tariffs, imposed under those specific executive orders citing IEEPA, are no longer legally in effect. They cannot be collected.
Wow. This decision is really a significant moment, then, in terms of presidential power and trade.
It truly is. It's a very powerful statement by the Court of International Trade, affirming the limits of presidential power under IEEPA, at least as applied in these instances. It strongly reinforces the separation of powers doctrine and reasserts Congress's primary constitutional role in setting trade and tariff policy.
Yeah.
The court has made it quite clear that IEPA is not an unlimited grant of authority for the president to impose tariffs whenever he declares an emergency. It's not a blank check, especially not when used as a tool for broad diplomatic leverage, or to address issues for which Congress has already provided specific, more limited legal tools elsewhere in the law.
So this deep dive into the court's opinion really shows that even in times of declared emergency, the power to impose tariffs isn't absolute. It's constrained by the specific words Congress used in statutes like IEPA and the Trade Act, and importantly, courts have the duty and the power to review executive actions to ensure those constraints are respected.
Indeed, it really highlights the critical importance of statutory language, legislative intent, and the overall structure of delegated authority in determining the legality of executive action, particularly when that action has such incredibly wide-reaching economic and political consequences as these tariffs clearly did.
Yeah, absolutely. Which brings us to maybe a final provocative question for you, our listeners, to consider based on the court's reasoning here. If imposing these broad tariffs as leverage to get a foreign government to change unrelated behavior is not allowed under IEP because it doesn't directly deal with the threat, well, what kinds of actions could the president potentially take under IEP that would meet that statutory test? What actions would have that direct link needed to address transnational threats like trafficking, or maybe even economic imbalances explicitly sourced outside the U.S. in a way that might pass this court's scrutiny? What specific, maybe more targeted actions might fit within IEPA's constraints, given the tools available to the executive in future emergencies? Something to think about as we watch how the executive branch might respond to this ruling and perhaps try to use different tools or strategies going forward.
That is a challenging puzzle, for policymakers and lawyers alike. The court's strong emphasis on a direct causal link, rather than just general pressure or leverage, suggests that any future IEP action related to these kinds of threats would likely need to be much more narrowly tailored, perhaps targeting specific assets or specific transactions or specific entities directly involved in the illicit activity or the specific economic harm itself, rather than imposing these kinds of broad duties on unrelated lawful commerce just to send a message. Much more surgical.
Fascinating legal and practical implications indeed. And that brings us to the end of this deep dive into a really significant court opinion.